My topic today is from a very broad perspective, which is routes in commercial and business litigation to obtain objectives for litigants. I've been in the business for some 30 plus years, 35 plus actually, and in recent years I've become ever more sensitive to the issue of the process of commercial litigation becoming the penalty. And I think that my views with respect to the most efficacious way to proceed in some settings has changed. I wanted to talk about the reasons for that because I think that's important for people who are selecting venues, whether they're doing so in the contracting portion of a business or when they're trying to select a venue after a dispute has arisen. I think that most of the problems that I am going to be talking about are a function of state and federal courts becoming increasingly preoccupied with enlarged caseloads, that this has had multiple implications for the decisional process with resulting delays in the resolution of the cases. Now, I recognize that commercial litigation takes many different forms, and I wanted to make comment with respect to objectives. Sometimes you want the process to be the penalty. Commercial litigation, in my view, is, except in existential litigation for the fate of a company, is typically business conducted by other means. And sometimes, for example, your objective is to slow the other litigants' path to come to market. In a particularly fast-moving market, a litigation with the objective of barring someone from competing or disabling them from contributing to a competitor can give you a leg up in getting to market. And so if you commence litigation to prevent that competition, you may want it to go as long as possible. So I know that in some cases litigants are looking for the process to become the penalty, but in most cases I feel that that's not true. So I think the landscape has changed, and next slide. Historically, my view has been that there's generally four different courses to follow. Those are laid out on the slide here. Those are federal and state commercial litigation, arbitration, and mediation. Now, obviously, parties can negotiate directly, but I'm talking about actual formal process involving some third party to help resolve the dispute. My perspective, as I'm going to communicate today, is that the first two have been changing. I think that my views of my involvement in arbitrations and mediations has been largely unchanged. I think that they represent the same benefits and drawbacks that they have historically in my practice, but I think that on the federal and the state side, in terms of litigation, there have been some significant changes, and they bear on choices of venue for commercial litigators. Next slide. Now, historically, I've looked at the various routes as having some true benefits versus drawbacks. Mediation, as laid out here, has often been the least expensive. If it's successful, it's the quickest. It's generally the least invasive of any of the choices. But the drawbacks have been, and this I've been disappointed so many times, if you don't have a quality mediator, you don't get anywhere, or unless the parties are so inclined. If you don't have a good mediator, the process is often a waste of time. And the benefits of it are that you can get someone of some specialization. Maybe they know your industry, maybe they know the legal issues, but typically the mediator doesn't have to get down to nuanced understandings. They can help you with the general posture of the parties. It's got its advantages. I found it in my practice using JAMS and some of the other large mediation resources. Maybe a third of the cases are successfully mediated, sometimes less than that. Depends on whether I'm feeling depressed about the prospects or not. Arbitration, for a lot of years, people have said, and I've heard it said many times, that it's generally quicker procedurally to resolution than litigation. That can be true. I currently have a large-scale arbitration with a Singapore entity that's been pending for 2 years and isn't even close to going to hearing. Arbitrations can become protracted. On the whole, maybe they're faster, but that's not always true. You can control your discovery more with arbitration, which makes that less invasive over time. You can sort of control discovery costs if you're so inclined. It's easier to get an arbitrator to go along with you than it is to get a federal court judge if you're seeking to have a less invasive and less expensive ESI discovery process. Arbitration can be less expensive despite arbitrator costs. People will say, well, it's more expensive because you have to pay the arbitrator, you don't have to pay a judge. But I found that typically you can save on the discovery side, and that more than offsets the arbitrator. The biggest problem with arbitration has been historically, and I think today, that it's very hard to exit it on contested motion because there's a perverse incentive. The arbitrator is better served to keep the arbitration going as opposed to disposing of it and reducing the docket. Most commercial litigation is going to rest on contract principles or other well-established principles where you can make motions. Not obviously there are fact issues in commercial arbitration, but and in commercial litigation generally. But I found that if you can get a good judge, if you can get someone who can give you attention, it gives you nuanced analysis, sharp judge. That's your objective if you want to resolve commercial litigation. Arbitrators don't do that typically, in my experience. That's been true for 25 years of doing them, and I probably, in my practice, I have 3 arbitrations for every actual litigation. Litigation is generally slower procedurally, but it gives you the better prospect to resolve on motion, particularly in federal court. It's often very invasive as to discovery and therefore expensive. You don't get to select your judge, and there's accountability for the judge and review of errors. I didn't mention it in the arbitration side. Hugely important, in my opinion, is that there's no accountability or prospect of review. There's no reasonable prospect of review if an arbitrator makes a mistake. From my standpoint, that often dictates that we don't go that way unless there's a contractual provision that's already cast the client down that path. Anyway, that's sort of the book as it was. And next slide. I think that the scenario has really changed a great deal, particularly in recent years. The ability to proceed in the courts has been materially and adversely affected, I think, by a whole host of things, and much of this is going to be anecdotal. And then I went back and I decided to test my experience and my anecdotal evidence against what I consider to be a terrific database that tracks courts. And I found that the data basically supports what I've been observing over the years. Caseloads at the trial level, and especially in the federal system, have been increasing. We'll get to other slides later which basically detail this, but the number of judges, and particularly the number of full-time judges, has declined significantly. And at the same time, caseloads have been going up. And the caseloads in circuit courts of appeal are also increasing significantly. And as a result, there are substantial changes in the timetable for getting resolutions. At the same time, the advent of big data has really imposed upon judges, in my view, a lot of objective standards that they need to answer to for administrative judges or those administrators that oversee the courts. They have goals and standards for moving cases. Those goals and standards require them to pay attention to older cases to get them off before they reach a particular threshold. And in my view, the decision of a court to attend to a case that's been pending too long, that they need to move off the docket, often means that that case is reviewed from the standpoint of assisting the court with its goals and standards, and not so much as paying as much attention to the litigants' arguments, the evidence, the law, and as they might otherwise. And as a result, I think that the pressure of administrative judges on the trial bench in particular has prompted decisional processes that are less optimal than they used to be. I see many more decisions that are taken either quickly with little analysis. And what I'd like to do is talk a little bit about anecdotes. In New York, there's 4 appellate divisions, and they're the intermediate state court. And I've talked to judges that are in the appellate divisions, and what they're talking about, basically, I complain as a commercial litigator that the decisions that we're seeing are awfully short. They don't have a lot of analysis. They don't get into the facts. They provide very brief explanations of what the issues are. They're hard to use as authority in other cases. And then the question I put to these judges, none of whose names I'll reveal, and say, well, why is this? And they basically say that the amount of time they have to devote to cases is less than they optimally would like to have, and that as a result, they feel better not getting into an analysis that may not be thoroughly vetted and set forth, that will then restrict them in a future case in a way that they don't want to have happen. And so the array of cases that are coming out for commercial purposes have been ones that are easy, or not easy, but susceptible to interpretation by litigants to different ends, and it makes it more unpredictable, especially in the trial courts in New York. Now, I don't know whether that's true in other states. I've got a case in a commercial court in New Jersey State Court where the state court judge, the commercial part, acknowledged that the plaintiff had failed to set forth a properly pleaded set of claims, and also had failed to provide proof of personal jurisdiction, and then commented on the record that that he'd been reversed enough times by the appellate court that he was just going to deny the motion. And my view of this is that a lot of these trial courts are looking at the decisions out of the appellate courts, and they're saying, well, I'm just not going to make a hard decision. For commercial litigators, that's poison. I mean, if I have a client, I'd like to be able to say, we have some predictability. And as I said a few moments ago, the courts provided more predictability and opportunity to exit a litigation. And I find that prospect, especially in the state courts, is declining. It's also declining in the federal courts. And I think that I see this in particular with the opportunity of courts to rule. They rule. I've had motions for reconsideration granted on 2 occasions in the last couple of years where I was surprised. The logic of the initial decision was solid, was solidly reasoned. It was based on solid authority, and the result of it was the court was just nervous because he felt rushed. And so from my standpoint, the changes at the trial court level and the appellate level has been altering the opportunity to obtain a motion to exit predictably, to provide solid guidance and the advantages that once were available in the courts over the arbitration and mediation alternatives that I laid out before. And next slide.
Before we get to that, let's do the first secret word, please. Business, B-U-S-I-N-E-S-S, business is secret word number 1. So jot it down so you can get your credit. Business is secret word number 1. And Doug, we can get right back to you. Just want to point out you have about 7-8 minutes left for your presentation. I know you have a few slides left, so just wanted to give you a time check, okay?
Sure. Well, the next set of slides, this is the documentation I went through, and I mean, first of all, I want to make a pitch for those who get down to this level of detail. There's a lot of data about federal courts in the Transactional Records Access Clearinghouse, which is operated by Syracuse University. It is an unbelievable resource. It allows you to look by judge as to what is going on. I tried to obtain some information. It's in these latter slides after this one. But basically, what this demonstrates is that the courts they're overburdened. The number of judges has been declining, and what shows on this is really not as representative as it might, because these are not full-time judges. If you look at full-time judges, the result, they've gone down by over 5%, while the caseloads have been increasing. Next slide. And I'm not the only person, I think, who's been looking at the delays as being something that's adverse, because if you look at this, even with there have been fewer lawsuits or fewer commercial cases filed. I was trying to look up what these are, and shareholder lawsuits. That's one of the things that I wind up in quite a bit, though they've been declining. And that wasn't just because of the Private Securities Litigation Reform Act of '95, which was before this data. And the majority of the suits that are on this don't include publicly traded securities. Next slide. I mean, it's similar information with respect to antitrust actions. As you can see, these are declining. Now, where's my slide here on, hang on here. One of the things that I found in looking this up is that the average period of time, and this is back on slide 5, that the average case in '93 took 16 months from filing the resolution, and that's now up over 2 years, and it's nearly doubled. So I don't. Now, obviously, complex commercial cases take longer than that, but what this demonstrates is that the courts are definitely backing up. Could we go to slide 8? The data also reflects that arbitrations have become more popular. The AAA has been reporting the ever-growing number of business-to-business arbitrations. I have some of the data on here as to slide 8. And the thing that struck me was that some 56% of the cases were resolved prior to award. That is something that I view as real positive compared to what I'm seeing in the federal and state court systems. My objective with commercial litigation is to get it solved. I see it as a dispute, a business problem, and all business people, as far as I'm concerned, are looking to get it resolved. That's an impressive number, and one that is material to me now. I look at arbitration somewhat more favorably as a result of that. Next slide. I also gathered some data with respect to rulings and mediation. Often with arbitrations, they're mediated beforehand. And I've included here some data as to how these things are being resolved, which ones are decided by arbitrators and when, and sort of the trend over time. And of course, it's a result of other means as well. This is to give anyone who's thinking about it some sort of sense of where the arbitration road can potentially go. Next slide. I think, and this summarizes much of what I've been saying, which is the time pressures that for judges have eroded the practices that are, calculated to give nuanced, thoroughly reasoned, correct decisions that apply predictable commercial law. And that's affecting both the federal and the state. The federal is still considerably better than the state, even though the states have started to adopt commercial parts to try to give commercial litigators a more sophisticated hearing. And New York has instituted commercial courts, and that's been a minor benefit. The one that's here closest to me that I sometimes have a case in, the judge has got 500 cases on his docket. That's more than most federal court judges, and I think that's led to a great deal of uncertainty. And I think a lot of it has to do with the spillover effect of the caseloads on the confidence of the judges who are asked to make these decisions. And they are therefore ever more unwilling to rule definitively on motion, and thereby have accountability for the counsel and the parties. They often listen to arguments that are borderline specious, and because they don't have time and they don't have the opportunity to basically tell counsel and hold counsel accountable for taking such risks. I also think that the courts, when they don't have time, tend to have a more practical view of what constitutes justice, and I think that the state courts, especially the New York courts with which I'm the most familiar, are tending to make them more like arbitrations. And I think that it's very hard, it's grown harder in the courts to be able to say with any degree of certainty how a state court in particular, and less so a federal court, will apply the law and the rules. So, next slide. My suggestions that come out of this for anyone who's looking at the issue of commercial litigation, business and commercial litigation, is that you need to think, I think, differently than I thought 10 years ago with respect to the courses for resolution. And those are choices that you can make in the drafting of agreements, to whether you want to choose arbitration as a means of resolution, whether you want to require mediation before you start. Maybe the data that I pointed out earlier would suggest to you that maybe you should have some combination of those two. Do you have the opportunity to get in federal court? And going back to the track database, you can even take a look at what your prospects are of getting a particular judge and what the outcome of that is if you do have a federal court. Something that is very well worth looking at given the stakes having gone up and the pressures having grown as I've described. You can check resources, and in this case I'm talking about something like track, which will tell you exactly how long that court and that judge has been taking with the various cases that they have on their docket. You can get that kind of fine detail, granular information about those judges before whom you may be, and that's something that's worth consulting early in a litigation if you're drawn into it, because it'll give you some sort of view of how long it might take to get resolved. And as it says in the last bullet point on that page, that will bear increasingly on whether to settle early or to emphasize mediation or to do something that may get you out of that court. So that concludes my formal presentation. How'd I do on time there?